Good morning and good evening. So good evening in Australia and good morning in Botswana. So my name is Aurélien Lorange from the Corax Foundation. You will have the opportunity to watch a day 2 match in this Group D between two universities. We'll be debating on a topic they received a week ago, so 7 days ago. This is the University of Melbourne in Australia and the University of Botswana in Botswana. So these two teams will be debating, but they don't know yet the positions they will receive, so we'll know it live in this session. And I want to enjoy as well to thank the judge who will be watching this match, the free judge. So many thanks again for your time and availability. Before we move to the match, let's start to ask simply each debater to introduce himself or herself for this match. So we start with Motlasi Sharon Mogorosi. Welcome. Yes, in Botswana.
Thank you very much for having me. Hi, my name is Mutlatsi Sharon Magorosi, and I am pleased to be here.
Thank you, welcome. We have as well in Melbourne Miss Cindy Nguyen. Welcome.
Yep. Hi, I am Cindy Nguyen, and I'm also pleased to be here. I'm a third year student at the University of Melbourne studying my JD.
Thank you, welcome. We have as well in Botswana Nomtandazo Nkube.
Hi, I'm Nomtanda Zangobe and I'm very happy to be here. Thank you.
Thank you and welcome. We have as well in Melbourne Mr. Joseph David Kalara.
Hi, my name's Joseph David Kalara. Pleased to be here.
Thank you and welcome. And we have as well third member in Botswana, Rorisang Morwang.
Good morning. I'm pleased to be here. My name is Rorisang Morwang. Thank you so much.
Thank you and welcome. And finally, third member in Melbourne, Mr. Jay Foster.
Hi, good morning and good evening. I'm Jay. I'm excited for this debate.
Thank you, welcome. So the two teams received a week ago a topic. So the right to culture requires states to safeguard libraries and archives whose loss would irreversibly damage humanity's intellectual heritage. So now I will share my screen for the allocation of position, and we'll see all of us on WebEx and on YouTube which position each team will have during this match. So as you can see, normally you should see a wheel with the double flags of each institution and two positions possible in favor and against the motion. The team will be in favor will be starting the match with the first introduction of 4 minutes. So now I'm activating. So for this match, the University of Melbourne will be in favor of the motion, and it means we'll be starting as well with the first introduction of 4 minutes. As a consequence, the University of Botswana will defend the position against the motion. So concretely, it means the University of Melbourne will defend the position that the right to culture requires state to safeguard libraries and archives whose loss would irreversibly damage humanity's intellectual heritage, while the University of Botswana will defend the position that the right to culture does not require state to safeguard libraries and archives whose loss would irreversibly damage humanity's intellectual heritage. So now you have 5 minutes to review your notes, and then we'll hear the introduction by the University of Melbourne. Voilà. So we are done with the 5 minutes of preparation. Mr. Bonhomme, welcome.
Thank you very much, and good day to the students. And of course, big thank you to the 3 judges that will be reviewing or possibly already are reviewing this match. I'll be your co-host for the meeting. Just a short reminder, I also give you visual cues for your speaking time. Yellow for 30 seconds remaining and red for your speaking time being up. If you see the red card, you don't have to cut yourself short. Comfortably conclude your sentence. And that said, without further ado, I would like to invite University of Melbourne for your 4 minutes for the opening position.
Hi, are you able to hear me well?
Yes.
Then I'll begin. 3, 2, 1. Good morning and good evening. I'm Celia Wynn, Principal Speaker for the Affirmative. We begin with common ground. We all agree here that libraries and archives should be created and maintained for items of cultural significance. The question in this debate is not whether they are valuable, it's whether the right to culture inherently imposes an obligation on states to safeguard those libraries and archives where their loss would cause irreversible damage to humanity's intellectual heritage. And we say that it does. That obligation is already embedded in international law and operates in a way that is proportionate, sensitive, and particularly protective of minority communities. And we will tell you why. Today we cover 3 main points. The correct textual interpretation of relevant international law. Second, why safeguarding is necessary for the right to culture to meaningfully exist. And third, severe consequences that arise when preservation fails. Moving to our first point, we turn to the legal framework establishing the right to culture. The most important instrument here is the International Covenant on Economic, Social and Cultural Rights. Article 15 of the Covenant performs 2 crucial functions. First, it states that states must recognize the right of everyone to take part in cultural life. And second, and more crucially, it states that states must take the necessary steps for the conservation, development, and dissemination of culture. Conservation is not optional language, it is an explicit observation, and accordingly, protecting libraries and archives that house humanity's intellectual heritage is a direct form of conservation. This is what states have signed up to and agreed upon in the Covenant. Moving to our second point, this interpretation is consistent with the purpose of the obligation for 3 reasons. First, the ability to take part in cultural life depends on access to cultural materials. The right to culture would be entirely meaningless if the very objects necessary to exercise it were destroyed. Libraries and archives are our primary repositories of humanity's recorded intellectual heritage, and access to these materials is therefore an integral component of cultural practice. Secondly, protecting these institutions is the only way to give practical effect to conservation. Once cultural resources are destroyed, restoration is impossible. A purely reactive model where states wait until destruction occurs makes the right meaningless. And history shows us what happens when preservation fails, and we've seen this through the looting of cultural artifacts during colonialization. The law exists precisely to prevent a situation where a community, decades later, seeks to reconnect with its history but finds the records have been desecrated or lost forever. And thirdly, safeguarding libraries and archives is particularly crucial for minority and Indigenous communities. Many Indigenous and minority communities possess oral and spiritual traditions that, in the modern world, depend on archival preservation. Today, libraries and archives record endangered spiritual practices, recordings of elders, and protect traditional ecological knowledge. And this protection is reinforced by Article 27 of the International Covenant on Civil and Political Rights, which guarantees that minorities have the right to enjoy their culture. If heritage disappears because it was never preserved, that right is rendered illusory. To conclude, we propose that the right is not unlimited. It is proportionate and applies to materials whose loss would cause irreversible damage to humanity's intellectual heritage. That exercise itself requires expertise, it requires cultural sensitivity and community consultation. It doesn't mandate preserving everything, only that which is vital. In short, the right to take part in cultural life requires access. Access requires preservation, and preservation in cases of irreversible loss requires state action. That is the only way to make the right real. And for those reasons, we reaffirm the proposition. Thank you.
Thank you. We'll now hear the opening statements by the team of University of Botswana for the against position. 4 minutes.
Thank you very much. I would like to make this House aware that the International Covenant on Economic, Social, and Cultural Rights protects participation in cultural life. The 1954 Hague Convention regulates wartime destruction, and UNESCO conventions promote safeguarding. But none of these instruments transforms the right to culture into an absolute mandate that requires states to personally safeguard archives. International law does speak the language of balance and cooperation, but it does not dictate institutional monopoly, and it does not solely rest the capability or the duty to safeguard archives or institutions or any other information that is important for humanity civilization in the state. First speaker from opposition will make two arguments. Firstly, that the right to culture is flexible and subject to progressive realization, and we must recognize that. And secondly, even where safeguarding is necessary, states are not the exclusive or necessarily best actors. On the first point, right, why is it that from opposition we believe that the right to culture is subjected to progressive realization and proportionality? Chair, it is important to recognize that Article 2 of the SCRS government wants to rely on is very clear. States must realize rights based on available resources. The legal principles of maximal capabilities, it makes sure that we understand that human rights are governed by proportionality, and there's a hierarchy of rights. And we don't think that in a nutshell, when we recognize that states differ in capacity, then we can say that where we must dictate that states must preserve or in competition with urgent social needs. For example, is when we prioritize during the COVID-19 era, there were so many cultural artifacts that could have been safeguarded, but because there was a priority of the right to life and the right to health, then we had to shift our priorities there. We also tell you from oppositions that because we recognize that states must safeguard rights in terms of what they can do, then we also have the logic that, well, we cannot then say that Article 2 then dictates that states must particularly and solely safeguard. Also note that the right to culture, or even the right to have access to culture and resources, is not absolute. It is limited by the capabilities of states themselves. Secondly, we tell you from opposition that when safeguarding is necessary, states are not the exclusive or necessarily best actors, right? We tell you that the Convention concerning the protection of the world cultural and natural heritage, as well as the Memory of the World program, operate through cooperation between states, civil society, academic institutions, and digital platforms. This reflects principles of subsidiarity, right? We tell you from opposition that the obligation of the state is to ensure access and reasonable protection, not to personally warehouse civilization or to personally warehouse these institutions that protect or archive these records. Moreover, from opposition, we like to caution this House that history has shown us that states can also be agents of censorship, political manipulation, and selective preservation. We think that we then expose the same marginalized communities that government wants to protect to censorship and even to selective preservation when we rest the duty to protect all these archives and information on the state. For example, in Cambodia during the Roge regime, when the state apparatus became the instruments of cultural annihilation, we can see that the state was wrong there. And it is time that we allow for collaboration and cooperation and preservation of information that can advance humanity's progression. This is why we think that cooperation between individuals, like how civilians rescued manuscripts in Mali during the Timbuktu wartime, should cooperate with the state and with academics and even with libraries, because we live in a world of digitalization. That is also something that we must consider, that we can have digital archives. So therefore, we don't have to have this duty solely rest on the state's proud to oppose. Thank you.
Thank you. We'll now hear the first rebuttal by University of Melbourne for the in favor position. You have 2 minutes.
Hi, can you hear me?
Yes.
Okay. Starting 3, 2, 1. It was UNESCO who said that culture is central to all rights, and without it, no other rights were possible, since it is the matrix from which all other rights must spring. Now, the right to culture is a significantly important right, and as so, it demands an expensive burden. Given this, it is important to recognize what this right actually entails. The opposition side has suggested that this duty would be overly and extensively burdensome, but this duty would not be as limitless as the opposition suggests. There are multiple indicia that these burdens are not as onerous as the opposition has characterized. Firstly, this duty only lies on archives and libraries that would result in irreversible harm. This already limits irreversible harm to humanity's intellectual heritage, that is. This already limits it to artifacts and cultural objects that are unique. Secondly, it limits it to artifacts that are not replicated or copied elsewhere. And thirdly, importantly, it is also limited to cultural archives relevant specifically to humanity's intellectual heritage. This is by no means a trivial requirement and greatly narrows the number of archives a state must guard. Regardless, the second article that the opposition side cited specifically asks that these states use to the maximum of their ability, their resources, to ensure that there is the realization of these rights, and these rights are accessible. Dealing quickly with their second point as well, on whether or not states are the best actors. Importantly, states are the one actor that has the capacity to continue over large periods of time. Archiving in libraries is something that requires consistent and considered effort on all parties. It is the states who are uniquely positioned to do this because they are not like private corporations which end shortly or have their ability to actively protect these things disappear, whether it's by disbanding the archives or whatever. Proud to affirm.
Thank you. We'll now hear the first rebuttal for the against position by University of Botswana's team. 2 minutes.
Hi, may I please confirm I'm audible?
You are.
All right. Just 2 minutes to set up my timer.
Okay, go.
Okay, I will start my speech in 3, 2, 1. Panel, it's important to understand that states are sovereign in nature and they should be sovereign. Hence, they have that principle to actually make their own decisions that affect their own pocket and that get to affect their own people. If we have a rule like this that is being set for everyone and for every state to follow, it means that states inherently lose their sovereignty to actually channel their funds in industries and in systems where they think it is suitable for them to. I think it's very problematic for a side of the house to come and say everyone has an obligation to follow this rule, even if we've currently told you that in a state where there are developing countries who do not even afford to have this system, they are now going to be forced to uphold the rights of an archive or if a library in the expense of actually improving the health sector or the educational sector, and we think we oppose that particularly. But on to that are opposing, we think that cultural rights are subject to progressive realization. This is something that you already get from my first speaker when she tells you about Article 2 of the International Covenant on Economic, Social, and Cultural Rights. We think that states fulfill rights based on maximum available resources, but it's also imperative to understand that this maximum resource has a minimum core. We think it's very important to understand that states can do certain things which they think they can do, but they can also not do certain things because it is imperative for them to understand that their planning can only be limited to what they think is okay. So we think the covenant does not mandate absolute preservation at all costs. In a developing state that is facing famine and pandemic and wars, we think that allocating massive funds to safeguard archives may violate these rights, and we seek to uphold each and every right necessary. Secondly, we think that minority rights can be protected through anti-discrimination laws, through education access, and through community archiving. And this is something that we can also use to uphold the culture. You can uphold the culture through education. You can uphold the culture through awareness. You can uphold the culture through any laws or through any education system that can be introduced. It doesn't necessarily have to be upholding the archives or upholding the libraries. Proud.
Thank you. Now for the second rebuttal for in favor position, University of Melbourne.
Hi, can you hear me again?
Yes.
Perfect. I want to be very clear. The right to culture is one that is intrinsic to all individuals in the states in which they participate. That is why, because it is an obligation of such crucial nature to all other rights, the burden should be, therefore, higher on these states. Now, I want to clarify that we are not suggesting, as the opposition suggests, an unlimitless burden in which they have additional or they're forced to go beyond their capabilities or their own means. No, particularly what we are suggesting is that they safeguard only the most significant of documents and protect and safeguard these archives. This does not mean funding them limitlessly. This does not mean providing them with unlimited resources, but crucially, that which is needed. They suggested that there is a sovereignty element here, in which this would impose on the state's ability to make its own decisions on how this is done. We note that there is no specific outlining as to how this safeguarding must be done, merely that they must be safeguarding. Additionally, other articles in international covenants, such as Article 13 of the ICE-SCR, provides specific and niche requirements on states. That one relates to education and requires that primary education is compulsory in all states. It is not novel or new to impose on these states an obligation that is specific, especially when it is as important in that case as education and in this case as culture. Lastly, they continue to suggest that instead states are not the perfect actor to safeguard these libraries and archives, and that instead states, it should be community archives and community archiving that does this. We note crucially to this case that these are not mutually exclusive. The state has the capacity to safeguard these libraries and these archives without imposing on communities and their ability to also create safe archives and libraries. Crucially, it is just requiring these states to impose or provide additional resources to ensure the protection of such sacred and important documents. Proud to affirm.
Thank you. For the second rebuttal in the against position, University of Botswana. 2 minutes.
Oh. Right. Time. I will start again in 3, 2, and 1. Finally, we think we need proper engagement in this debate. Number one, why is it so imperative for the state to be the one to undertake this? Because we think this problem of being of marginalized groups and everything exists particularly because we have given so much responsibility to the state. We might as well come here and tell you that we think it is best for these marginalized groups to actually take it upon themselves to safeguard their culture. They need to prove why it's so important for the states to take up this responsibility. Regardless of everything that we've told you, that there might be limited funds. We understand that they're telling you that sometimes the state is not going to be forced to do this. But when a law like this is being said, it means that the state are bound to do this. Number two, they have to prove why it's so essential to safeguard the physical libraries and the physical archives. Because my speaker already tells you that we think it's very important to understand that we are already embracing the digital era. So they need to prove to us why it's so imperative to protect these physical libraries when there are a lot of ways to preserve culture. And we've already told you about education, about awareness and everything. But number three, a very important question that we want to pose into this house is who defines which archives qualify? Because if you base this on the state, we tell you that the state also has an agenda or an obligation to prove or something to push. So who gets to define which archive is qualified to be saved? But number two, what criteria are we basing this archive? We don't think that they win this debate because they leave all these things vague and we do not have a debating ground. But number three, what happens if a developing state is to disagree on these things? We think we don't get all of these things and we don't get all of our questions answered from side proposition. And the only way for them to win this debate is to answer all these things, all these questions that I've asked. Why is it so important to safeguard the physical libraries when we are supporting digital world? Why is it so important for the state to be the one to lead this when we've already told you where the state suffers and where the state cannot really suffice? Thank you.
Thank you. We'll now proceed to hear the concluding statements. University of Melbourne, you have 2 minutes.
Hi, sorry, are you able to hear me?
Yes.
Perfect. Thank you so much. I'll start in 3, 2, 1. Good morning and good evening, ladies and gentlemen, esteemed judges and members of the opposing team. My name is Joseph David Kalara, and I speak on behalf of the affirmative team. Now, this debate is about two things. The first is about what the legal international right of to culture means. And secondly, why is it so important that we must place this obligation on states for this right? Now, the affirmative's assertions are clear. This right to culture necessitates an obligation of states under international law to conserve its libraries and archives. And we stress this motion in two ways. The first is that the access to cultural materials are important. They are the foundations of the right to culture. And under Article 15 of the International Covenant on Economic, Social, and Cultural Rights, as well as under Article 27 of the Universal Declaration of Human Rights, there is an implication provided on international law. The second is that they provide institutions of preservation and conservation, as well as a forum for restoration. And so without these institutions, it would be difficult to retain cultural artifacts and customs. Libraries and archives provide protection from instances of cultural erasure, such as the forced assimilation of Native American children in boarding schools, the destruction of cultural artifacts and historical sites. Now, let us be clear, we are not saying that technology will not inevitably improve the process of curation, maintenance, and preservation, as the other side have brought out, but the affirmative side firmly believe that the libraries and archives provide a foundation for intellectual heritage to be protected. And so, the question then becomes, what excuse remains for denying the protection for intellectual heritage? Thank you.
Thank you. For 2 minutes of concluding statements for Deacon's position, University of Botswana.
Okay, I will start my speech in 3, 2, 1. Panel, as the opposition, we affirm to you that the state has no absolute obligation to safeguard libraries. The state ensures that the people in their respective cultures uphold their culture. Panel, we tell you that cultural preservation is not important. It is absolute. It must be balanced against constitutional obligations like the right to health, the right to life, and the right to education often require more urgent allocation of the limited resources that are there in developing states. Panel, we also tell you that my learned counsels over here has already mentioned that the International Covenant on Economic, Social, and Cultural Rights makes it clear that social economic rights are subject to progressive realization. States must act within their available resources. Therefore, it makes sure that developing nations, if they do not fully prioritize this safeguarding archives, doesn't make it a violation of human rights. Right? Panna, we also told you that there is a mere way to uphold culture, which is through what? There's more ways to uphold culture, which is through educational awareness. As we tell you that preservation today is not only physical, the international cooperation and bodies like UNESCO have already introduced digital archives. That means we do not only have to save them physically, but we can save them digitally. Therefore, we stand firm that states should take reasonable steps to preserve cultural heritage, yes, but the right to culture doesn't impose an absolute enforceable duty to safeguard all libraries and archives regardless of context. Then we tell you that it is not the duty of the state. It is the right of every member to preserve their culture. And with that, we are proud to pose. Thank you.
Thank you very much. Thank you to both teams. Well done on concluding and executing your day two match, the tournament. You can all now relax. You are no longer under evaluation from this point. As always, we thank the three judges. Personally, I think they are going to have quite a challenge in this day two round for all the teams that we have had the pleasure, yours included, to observe your matches. But already now you have the option to share the feedback on how the preparation was for your teams. If you perhaps heard familiar arguments from the other team that you have encountered during your preparations, and how you found the exchange today, starting with University of Melbourne, Ms. Nguyen.
Hi, so in terms of my thoughts on the competition, I thought it was really brilliant. It was definitely a learning experience in the sense that it was essentially a series of exercises on articulation and how to articulate ourselves on international law matters, and looking into all those things was incredibly edifying for myself, and I'm sure for my team members as well. It was a great experience. I think we've learned a lot, especially under the coaching of one of our professors. So yeah, I think I'm very happy with what's happened today, and I think I also have learned a lot from our colleagues on the other side.
During University of Botswana's Ms. Moperosi.
Today's round was it was very heated. Yeah. The debate was very interesting. It was great. I really enjoyed it. I could feel myself trembling when the government speakers were speaking like, yeah, ne. We really have to oppose now. But with everything that went on in terms of preparation, our opposition was as strong as we saw it being. So our preparation was okay, right, guys? It was, yes. Our preparation was grand, and even the round was also grand. So
Thank you. Mr. Foster of University of Melbourne.
Yeah, I think the debate went wonderfully. Oh,
Yeah, no, sorry, got it.
sorry, yeah, I thought the debate went wonderfully. I thought the arguments put forth by our learned friends on the opposition, they were really well put. And I think we had kind of like similar ideas that came through, and they just managed to structure them really well as well. I thought overall the motion was really interesting. I think it got us looking at doing some research and whatnot, especially on some of the covenants that we hadn't really covered through classes, and I think that was really a unique opportunity to look at those things. So really enjoyed it.
University of Botswana, Ms. Mkube.
Hi again. As my partners already said, this round was very interesting. It was very engaging. We really enjoyed being here. And then in terms of preparation, yes, we truly, on the other side, we truly did enjoy preparing for the side government, the affirmative side. So when we heard our opponents raise the same ideas that we had, we're like, so we're probably on the right track. So yeah, we had more fun enjoying the rounds that we didn't get, but we had more fun again debating the sides that we thought or hoped we would not get. So yes.
Mr. Kalara.
Yes, I'd like to echo all my colleagues' notes on this particular prompt. It definitely threw a spanner in, I think, everyone's works, having to look into a lot of different things that we're normally not exposed to in class. I think it was gratifying to have gone through all that research and then to hear the other side echo exactly what our research had brought us up to, and to hear it articulated as well. So it was quite nice, yeah.
Thank you, Ms. Merbank.
Well, I really enjoyed today's round, especially me and my partners. Like, we did hope we are going to not get the side that we got, but yeah, it was really challenging for us, to get to experience, the best of both worlds in terms of, well, last time we debated proposition, this time is opposition. So yeah, we did really have fun, and we didn't have problems, we didn't have problems when we were prepping for this round. So yeah, we enjoyed. Thank you.
Thank you. Thank you, everyone. We are glad that you enjoyed the topic as well for the exchange and from different positions. And a question to both teams. You can choose, of course, which one of your members starts the answer. Perhaps have you already seen some of the other matches from this edition, or perhaps the previous editions? And if so, was there a team or a debate in particular that made an impression or that motivated you or challenged you in your own preparations or going forward? Starting first to the question to University of Melbourne.
Our team did have a look at a couple of previous matches. In particular, we had a look at our neighbour, Monash University, because we're both in Australia. Yeah, I think we drew a lot of inspiration from the way that they spoke, some of the ways that they broke down the themes that they had for those particular debates. And it proved really helpful in just forming our own opinions on how to prepare for our own matches. So I'm keen to see more matches from everyone else and to learn from our colleagues.
Yep. Thank you. For your team members, if there's anything you want to add. Okay. So passing the floor, same question to University of Botswana. Have you seen any of the matches this edition or previous, and perhaps what was the one that was impactful?
Well, I think the one that was impactful for us was the finals for last year, the Hague versus Lusaka. We really liked their train of thoughts and everything, you know, like thinking it's two people from completely different continents coming together to kind of discuss an issue on this international laws and international relations. It was very nice, and more so because it was like some form of representation from Lusaka, who would be our brothers and sisters. So it was very nice, and it was an inspiration to say, if they can, we truly can also do this. And if they have the certain thoughts and there's certain ways of thinking and articulating themselves, or even being in such a global stage, discussing such global issues, it means that we can also do it. But I feel like it was a very good competition, and a lot of ideas were shared there, and their preparation you could tell that they had great preparation by the way they delivered all their speeches. So it was an inspiration to us. It really was very great.
Thank you for sharing. And finally, final question would be, you already hinted at it in your previous answers, so perhaps this won't be much of a surprise as a question. In terms of skills, what are the skills when it comes to perhaps legal articulation, or just in general that you use in your life that you are being challenged to improve or are particularly using during the competition so far? Again, first with University of Melbourne.
I think clarity of structure, I think, is a big thing, being able to articulate the ideas of which you have. I think over the process of kind of brainstorming, we generate a lot of different ideas. And so just finding a way to structure that in a way that is cohesive, coherent, and is clear to an audience, I think that is something that was at least a challenge at first, and especially given the time constraint, 2 minutes for a rebuttal or 2 minutes for a conclusion, or even 4 minutes to have the substantive portion of your argument. I think just finding a way to say it in a way that's particularly concise, yeah, that was definitely something that we all really focused on.
Thank you. Same question for the team of University of Botswana.
Well, I think the skill that, I could tell for us, mostly for me, is, the analytical skills. You know how to just break down like points, until asking a question, it's why, until you can answer why. Also, listening skills is very, viable because it's different accents, it's different continents. You actually have to invest into listening and able to interpret what other people are saying. Also, articulation is very important because, this is a platform for one to just improve how they deliver their words, to mind the words that they're saying before they even say it. So, yeah, that's what I can say. Thank you.
Thank you very much. And for the wrap up of today's session, I will be passing the floor to Professor Van Hage
Yeah.
to complete. Thank you.
Yeah, so well done to both teams. That was really enjoyable to see that debate.
You are on mute.
Voilà, sorry. So well done again for this match. That was really enjoyable to watch and to observe. You will receive, of course, the results in 2 working days or right after the weekend, maybe. In case, well done, congratulations. I want to thank as well your coach. So on Melbourne, special greetings to Wayne Jokic, and special greetings as well in Botswana to Innocent Diteko and Boago Motimola. So thank you again for helping the teams during the competition. So we keep in touch, and don't hesitate also to keep in touch between the teams. So thank you again, and we'll see you in the day 3 match very soon. So thank you again. Bye bye.
Well done. Goodbye.
Well done. Bye bye.